You're tuned in to Agriculture Today, and we start our Wednesday show with an agricultural law update with K-State and Washburn law professor Roger McEowen. Roger, thanks for joining us today.
Good to be with you, Shelby.
Roger, today talking about prescribed fire in Kansas and some of its rules and regulations.
Prescribed burning, first of all, is pretty critical to agriculture, and it's a key component of rangeland management. And, of course, we have experts at K-State that deal with rangeland management. But then when rangeland management issues go awry, then they get to talk to people like myself. And we get into issues concerning prescribed burning, which is a big issue in the Flint Hills, particularly in the month of April. But it's already started in some areas. And it also helps us limit wildfire risk, let alone manage the rangeland itself. So it's a big issue, but all of the states in the Great Plains, including Kansas, have regulations that specify how an open burn of agricultural land is to be conducted.
When people come out to say no burn ban, does that always apply to agricultural prescribed fire?
No, there's a major exception for agriculture. Now, in general, there's a burn ban, but agricultural activities constitute a major exception to that general rule.
And so when people are working on going to get that prescribed fire and start off burning, are there a few people they need to notify before doing so?
Generally, yes, and particularly if wind conditions might result in smoke blowing toward a public roadway, then you have to give notice to such entities as the Highway Patrol if it involves a state highway, local people such as a county sheriff or local traffic officials if we're dealing with local issues and we don't have a state highway or an interstate that's involved. And you need to contact them before the burn is started, and that's in the administrative regulations that govern open burning of prescribed agricultural lands in Kansas. You can't create a visibility safety hazard. That's the basic rule. But we also can't control the wind, and sometimes the wind will shift after a burn has been started. So that's why these notice requirements are in the rules. And use common sense. You can't burn in an area that would obstruct air traffic, for example. So there's a reg that applies with respect to burning near an airport. Then if you could create a potential hazard for air traffic, then you're going to have to notify airport officials before the burn begins. So again, just kind of use common sense. Who should I be notifying in these instances that I am going to conduct a burn? But you have the right to conduct the burn.
And are there some rules and regulations around what conditions people should be burning in and what time of day?
There are. You don't want to start a fire close to evening hours, and you need to have it extinguished or controlled. And there are rules with respect to what control means. And the burn has to be supervised until it's extinguished, and there are specific regulations on all of that. The burn regulations also allow local jurisdictions to adopt more restrictive ordinances or resolutions that govern prescribed burns of agricultural land. So you always want to be familiar not only with what the state regulations are, but to see if your local government and local officials have enacted different rules or more stringent rules than what the state regulations say. So you always want to be familiar with those too.
And as we're getting close to April and thinking about some more rules and regulations that could be taking place, there are some counties in Kansas where certain burning is prohibited.
There are, but again, there are exceptions during the month of April in these counties. But in the counties of Butler, Chase, Chautauqua, Cowley, Elk, Geary, Greenwood, Johnson, Lyon, Marion, Morris, Pottawatomie, Riley, Sedgwick, Wabunsee, and Wyandotte counties, then the regs say in those counties, and those are going to be your Flint Hill counties largely, that the open burning of vegetation and wood waste and structures or any other material on any premises during the month of April is prohibited. But obviously we say, well, how can you say that? Because we always burn the Flint Hills in April. Well, there's a major exception to the regulations on that. Prescribed burning of agricultural land for the purpose of range or pasture management, as well as the burning of CRP land that is conducted in accordance with the requirements for a prescribed burn of agricultural land, is permitted during the month of April in these Flint Hill counties.
What about for those who are wanting to do non-agricultural open burning activities?
Well, they also have to meet certain requirements, including a showing that open burning is necessary and it's in the public interest and it's not otherwise prohibited by public government or local government or any fire authority. So again, the answer is they can do it, but make sure that they're in tune with the governing regulations that apply in that particular situation.
Wanting to talk about a few different legal things that could be involved with prescribed fire, and the first one being negligence.
Well, that is the rule in Kansas. The courts have said that farmers have a right to conduct agricultural burns, and it's not a strict liability approach, so it's a negligence approach. And what that means is that it's based on the facts and circumstances as to how I conducted the burn, and of course, was I following all of the regulations that were in place? And if I wasn't, then that would be evidence of negligence in conducting the burn if somebody is harmed by what I've done. If I cause an injury or an accident to occur, or I burn somebody else's property and it gets away from me, those types of things. Well, I'm only liable under the theory of negligence. They have to prove somehow that I was negligent in conducting the burn. And one way that they can establish that is I didn't follow the rules. I didn't notify authorities that needed to be notified. I didn't have the fire under control. I didn't monitor it until it was extinguished, so forth and so on. That would all be evidence of negligence. So it's a reasonability standard, and these cases get tried to juries. And so you don't want to get to a jury because if they don't like you, that's just kind of the way it goes. You may get a negative verdict from the jury and then have to go on to appeal. But the way it's conducted is what we look at in these types of situations to determine if there was negligence.
You wrote a blog article about this, and within there's an example. And would you mind sharing that with our listeners?
Yeah, and the example basically is, let's assume that we've got a rancher in Kansas that's followed all of the rules to prepare for and conduct a prescribed pasture burn. But after conducting the burn, the rancher banks the fire up and leaves it in what he thinks is a reasonably safe condition before heading to the house, say, for lunch. And over lunch, the wind picks up and spreads the fire to an adjoining tract. Well, if the burning of the neighbor's property wasn't reasonably foreseeable, then they can't sue that rancher for negligence. They can sue, but it's likely not going to be successful. But if the wind was at a high velocity before lunch and all the adjoining property was extremely dry, it probably was foreseeable in that instance that the fire would escape and burn a neighboring landowner's tract. So foreseeability, again, depends on the facts. And was it reasonably foreseeable? And so there are lots of cases on the issue of reasonable foreseeability in general. There's a couple of famous cases on it, not so much with respect to pasture burning, but the same principle applies. And again, use common sense. If you bank up the fire before noon and head to the house to have lunch, what were your weather conditions when that happened? If you did it when it was windy and you knew that, that's going to be a problem. If the weather conditions look like, hey, everything's under control, I can take a break for a bit, that's probably not negligence. So it's very highly fact dependent.
And some other things to think about when it comes to prescribed fire and legal liability: intentional interference with real property.
Well, that is another legal principle that can apply in open burning activities, and it's closely related to the issue of trespass. So if I'm intentionally interfering with my neighbor's property, then I'm basically trespassing against them. And that's the unauthorized or unlawful entry upon somebody else's land that interferes with their exclusive possession and ownership of that land. So at its most basic level, it's something I'm doing to my neighbor's property that I don't have their consent to do. Well, we get into this with respect to drift issues. And there are some cases that are out there where a fire was lit and they knew that the wind was going to carry it directly to that person's home. And it created such a mess that the court said, well, that was an intentional trespass. So the court didn't use the negligence standard in that one. They used a trespass standard because of the facts. So that's not a Kansas case. What I'm referring to that is an Oregon case, where in eastern Oregon they do burn in the Palouse area. So that's another principle that's there. But strict liability rules do not apply in Kansas. What I mean by that is we don't care if you're negligent or not. If you did a pasture burn and you cause problems, then you're responsible. That is not the rule in Kansas whatsoever.
What is the rule in Kansas for prescribed burning then?
It's a negligence rule in Kansas. Farmers and ranchers in Kansas have the right to set a controlled fire on their property for ag purposes, and they're not going to be liable for damages resulting from the fire if it is set and managed with ordinary care and prudence, depending on the conditions present. And that is Kansas case law on that. We had a prominent Kansas case in 1996 that set forth that standard. So at least at the present time, and that's held for almost 30 years, and the longer a court opinion hangs out there, the tougher it is to have that reverse. So that's pretty solid law in Kansas. But still, at the present time, the courts have determined that there is no compelling argument for imposing strict liability on a property owner for damages that result from a prescribed burn of agricultural land. And that's the key take-home point.
And while we are talking about Kansas, are there similar rules for our neighbors to the south?
The liability rule that I just mentioned also applies in Texas and Oklahoma. It's a negligence rule. It's not strict liability. So again, carefully following prescribed burning regulations is going to go a long way in defeating a lawsuit claiming that the damages from your prescribed burn were the result of negligence. Just make sure you know what the rules are, follow what those rules are, check your local rules and see if they're more stringent than the state regulations on that, and you should be in good shape.
Roger, I appreciate you taking the time to join us today and share with us some rules and regulations when it comes to Kansas prescribed burning.
Thanks for having me.
That was K-State and Washburn law professor Roger McEowen. I will link a blog article in today's show notes if you'd like to read more on this topic.